This is passage number 12. Duration 6 minutes. Speed 100 words per minute. Dictation starts now. Para. The present appeal is filed by a consumer against the order of the District Consumer Redressal Commission regarding the supply of a defective motor vehicle. The appellant had purchased a luxury car from the respondent dealer by paying a substantial amount of 40 lakh rupees. Within a week of the purchase, the vehicle started showing major mechanical issues and frequently stalled in the middle of the road. Despite multiple visits to the authorized service center, the technical team failed to rectify the engine problem. The appellant claims that he was sold a lemon or a defective piece which has caused him immense mental agony and financial loss. Para. The learned counsel for the appellant argued that under the Consumer Protection Act, a manufacturer is duty bound to ensure that the product sold is free from any latent defects. He submitted that the persistent breakdowns in a brand new vehicle clearly indicate a manufacturing defect. It is further contended that the dealer and the company acted in a negligent manner by not replacing the vehicle or refunding the full amount. In today's competitive market, a customer expects reliability and safety when they invest their hard earned money in a premium product. The failure to provide a defect free vehicle constitutes a clear deficiency in service. Para. On the other hand, the learned counsel appearing for the automobile company submitted that there is no expert evidence on record to prove any manufacturing defect. He argued that the issues reported by the customer were minor in nature and were caused due to improper handling of the vehicle. According to the company, they are only liable to repair or replace the faulty parts under the warranty terms and not the entire vehicle. The respondent maintains that they have already provided the best possible service and have even offered an extended warranty as a gesture of goodwill, which the appellant has refused to accept. Para. We have perused the job cards and the correspondence exchanged between the parties. It is observed that the vehicle was taken to the workshop 10 times within the first 3 months. This fact itself speaks volumes about the quality of the product. A consumer who buys a new car does so with the hope of a hassle-free driving experience and not to visit the garage every second day. The law is intended to protect the interest of the common man against the unfair trade practices of large corporations. The technicalities of the warranty period cannot be used as a shield to supply substandard goods. Para. Furthermore, the consumer forums must adopt a practical approach while deciding such matters. If a machine requires frequent repairs from the very beginning, it is reasonable to conclude that it suffers from an inherent defect. The burden of proof in such cases should not be made so heavy that it becomes impossible for a common citizen to seek justice. The compensation awarded must be commensurate with the hardship suffered by the buyer. In our view, the respondent company has failed to maintain the standards of quality that it promises in its glamorous advertisements and brochures. The dignity of a consumer must be respected. Para. In light of the facts, we direct the respondent company to replace the defective vehicle with a new one of the same model. If a new vehicle is not available, the company shall refund the entire purchase price along with interest at 9% per annum. Para. We also award a sum of 50,000 rupees towards the cost of litigation and mental harassment. The order shall be complied with within a period of 30 days from the receipt of this judgment. With these directions, the appeal stands allowed. The registry shall send a copy of this order to both the parties for information. The original records of the lower commission be dispatched forthwith to the concerned office. Over. Stop.